Central Indiana studios. This is the CBS 4 News.
An Indiana judge's decision could fundamentally change abortion here in the state. The Indiana Attorney General's office says it's appealing that decision.
CBS 4 State House reporter Hannah Adamson breaks down the decision and how likely it is to survive an appeal.
Last week, an Indiana judge ruled that the state couldn't impose its near-total abortion ban on individuals who have a religious exemption, a decision that could have widespread ramifications for abortion care should it be upheld. After years of legal back and forth, a Marion County judge agreed with the ACLU of Indiana that the state's abortion law imposes a quote-unquote substantial burden, specifically on religious beliefs protected by the Religious Freedom Restoration Act, or RFRA for short.
The judge determined that the state had failed to establish what we call a compelling interest in enforcing the abortion ban against women who held a sincere religious beliefs in these circumstances.
Law professor Jody Madeira says if the judge's decision is upheld, it opens the door for anyone to access abortion care on religious grounds.
This ruling does not strike down Indiana's abortion ban in its entirety. It only limits its applicability basically to women who can articulate a reason for religious exercise.
The Indiana Attorney General's office has appealed the judge's ruling, a statement reading in part, quote, "As we have with every challenge against our pro-life law, we'll continue fighting to protect the lives of the unborn." The group Indiana Right to Life says the judge's decision is distressing and twists what the law was intended to do. Madeira says if the ruling is upheld, state lawmakers could try to bypass that ruling by making tweaks to RFRA. But she says if that happens, that wouldn't come without constitutional concerns.
They would have to take the chance that they're going to trample on the religious freedoms of citizens in ways that no legislature can. So, in other words, there are things that the General Assembly could do that would be unconstitutional in light of higher constitutional powers, perhaps.
Madeira says it will most likely take several more months to make its way through the Indiana Court of Appeals, after which point the Indiana Supreme Court will most likely need to decide if it wants to hear the case. Reporting from Indianapolis, I'm Hannah Adamson.